Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I'm going to continue my discussion of Bill C-21 by looking at the grandfathering provisions in it. So there's a lot to get to here. There's a whole lot going on. So let's dive in. So the first thing I want to point to, we've got this section here, which is sort of the grandfathering section of this new bill. Starts out with subsections 12.8 and 12.9 of the Act, that being the Firearms Act, are repealed. So what are those sections? So those were grandfathering provisions. Now, these were brought in very recently by that's the Liberal Party. So they actually put these in, and when they did, I was telling people, hey, the only reason they do this is because they're planning on banning something. And a lot of people thought I was crazy at that point, but not crazy. Just sometimes I can predict the future from sort of obvious signs, because there's no reason they'd put in those grandfathering provisions if they weren't intending to, to ban something such that they'd have to use them. Now, so they introduced these, I think it was 2019, and now they've changed their mind. They don't like these provisions. They want to get rid of them, notwithstanding the fact that it was them that put them in super recently. So why do they want to get rid of them? Well, because they think these ones are too permissive, so they want to make much more restrictive grandfathering provisions. So they call them non-permissive storage. And this one is a grandfathering provision that's just specifically limited. The old ones were sort of set up so that they could be used for any sort of ban. This one is specifically limited only to those things that were prohibited under the May 1st, 2020 Order in Council. And it has several restrictions. The first restriction is that it has to be something that was banned by that Order in Council, so it doesn't apply to anything else. The next is that you possessed the firearm on the prescribed date or had acquired it by that day. And in the case where the firearm was a restricted firearm, on that day, the individual held a registration certificate for the firearm or had applied for a registration certificate that was subsequently issued for the firearm. Now, this is going to be interesting because this bit of legislation clearly contemplates that one could be granted a registration certificate after the fact. So currently, that's not the position of the Attorney General. So this little bit is probably going into a factum later. We'll see how that goes. But I suspect if the Attorney General of Canada is watching this one, you might want to look at this section because I think it undercuts your position. Before the prescribed date, the individual applied for a registration certificate that was subsequently issued and provided the prescribed information related to the storage of the firearm to a chief firearms officer. And beginning on the prescribed date, the individual provides the information referred to in paragraph C, which is, so it's when an application is made, when an application is made for an authorization to transport the firearm for storage, and within 30 days after the day on which a prescribed change is made with respect to the storage of the firearm. Now, all of this is part of their sort of municipal storage and restrictions provisions. So it'll tie into that. That'll be for a future video. I'm not going to cover that today, but just so you're aware, that's something that is going on here. Now, they've got various regulations here. You're eligible to hold a license if you possessed it on the prescribed date or acquired it by that date. Basically, a lot of the same things here. So that's provision of regulations made under Section 117.15. So this is for other stuff other than May 1st, 2020. Same sort of rules. No further acquisition, so this does not authorize the holder to acquire any prohibited firearms referred to in that subsection, which means that this is very different from if you have, say, 12.6 status, where you can go and buy other 12.6 firearms. For those who are not sort of gun people, 12.6 is short barrel firearms. And so you can see, this is the Firearms Act. So it refers to these different subsections. So 12.3 converted automatic, 12.2, automatic firearms, etc. So that's sort of gun owner parlance, where we'd say somebody has, 12.3 status, which means that they're able to get converted automatic firearms. However, this doesn't allow that. It only allows you to have whatever you had at the time. So if you lose it, you won't be able to replace it. Now, there's also an interesting provision here, exception upper receiver, because these exceptions are for firearms, not for prohibited devices, and they're designating the upper receiver of AR-15s to be prohibited devices. So this grandfathering clause doesn't include upper receivers for AR-15s except as provided for in this section. And that notes the upper receiver of a firearm referred to in item 87 of part 1 of the schedule to the regulations prescribing certain firearms, for which an individual holds a license referred to in subsection 1201, is not considered to be a prohibited device if the firearm is equipped with it on the date referred to in paragraph 1201 sub 1 sub A. So that's the prescribed date, which we don't know, but it's quite possibly May 1st, 2020. And it remains attached to the firearm. So previously I'd said there's nothing wrong with breaking down or stripping an AR-15 for parts. Today I'm going back on that in a very big way. If you have an AR-15 that is not assembled, assembling it is kind of like this. Basically says if it's not assembled on whatever date they specify, then you can keep the receiver, but you can't keep the upper. So you can keep the lower receiver, but not the upper receiver. So yeah, you want to keep those parts together. Just, something to be aware of is this little bit is potentially quite nasty, because if you have those two as separate parts, notwithstanding the fact that they're both together, that you consider them part of one gun, you may be grandfathered to possess the lower receiver, but not the upper receiver. And the lower receiver is not going to do a whole lot of good for you. Also note that they have to stay attached. So if you detach them, then the upper receiver becomes a prohibited device. So if you're wondering what you can do with something like this that's grandfathered, well, that's provided for here. Must not be authorized to transport a prohibited firearm. In the case of a prohibited firearm referred to in those sections, for the purposes referred to in subparagraphs 1B, 1 to 3, and that's of subsection 19 of the Firearms Act. So let's go and have a look at what those sections are. Those are if you change residence, if you wish to transport the firearm to a peace officer or for registration or disposal, if you wish to transport the firearm for repair, storage, sale, exportation, or appraisal, and not for gun shows. So you will not be able to take an AR-15 to a gun show at all, which kind of seems weird because gun shows occasionally have prohibited firearms at them. You are also specifically not going to be able to use them for target practice or target shooting competition, or for providing instruction as part of a restricted firearm safety course. So this is specifically barring you from using them for target practice or target shooting competitions. So those things are things that they want to specifically exclude here. So essentially, what you'd be able to do is just store this and do nothing with it. So that's one of the things that they were changing in this. Frankly, I mean, this doesn't seem to make a whole lot of sense to me, because if you are allowed to own it, why wouldn't you be allowed to use it for lawful purposes? Quite frankly, it seems like the goal here isn't a public safety goal, that the goal is instead a sort of restriction and control sort of goal, because I don't see a whole lot of public safety purpose in preventing somebody from going to the range and shooting a firearm they lawfully own. But, our government, in its infinite wisdom, seems to have a different view of that. Anyway, I think this is interesting because not least of which is that they are sort of turning on a dime here, where they've said, oh, here's what the grandfathering provisions will look like, and then now we've changed our mind. I suspect that they got some pressure from lobbying groups and have, and that's why they were doing that. But what they are doing is they're replacing some very simple grandfathering language with really much more complicated grandfathering language. And frankly, it's one kind of wonders why they don't just use the same sort of grandfathering provisions as the existing language. It seems here that they're sort of trying to split the baby. I suspect a lot of this is that they're realizing that people are going to be more upset if there aren't grandfathering provisions. They're probably also, to be frank, looking at the cost of the buyback, because the buyback is going to be incredibly expensive. And I suspect that they're saying, well, if we allow these grandfathering provisions, then the buyback will be cheaper. So that's kind of what we're looking at here. It's a bit of a mess in terms of what they're doing, but hopefully I've explained sort of how these new grandfathering provisions would work. As noted, not a whole lot you can do with it. You can just own it. That's about it. It can just stay and live in your safe. And of course, they're wanting this to be subject to these municipal rules, which for a lot of gun owners will be a real sort of difficult situation, because if you live in a city, well, what do you do, right? Do you leave the city if your city decides that, they want some special rules? Anyway, the municipal stuff I will be getting to, because it is a big deal. It's complicated, and I think that that one's going to be a long video. So it's one I'll get to a little later. There's a few other issues I want to cover first. Anyway, thank you for watching. I'm going to continue sort of picking apart this bill. Please like this video. Please share it with your friends. Subscribe to see more content if you've enjoyed this, if you like legal commentary. I also want to thank my Patreon supporters. There's a link to the Patreon below if you want to become one of them. At the $50 level, DMO, Sir Daniel Wicks of Alberta, Canada's National Farms Association, North Central Process Service, and Kyle Martin. At the $20 level, Cameron Johnson, Dale Nesbitt, Andrew Elsich, and Sights and Arms Limited, as well as quite a few of you at the $10 level who will be in the crawl immediately following. Thank you once again for watching. I appreciate it, and I hope I've armed you with knowledge.